Hello, everyone. Welcome back once again to the second session. Okay, so let's begin now. I hope you've had your lunch, tea, coffee, whatever helps you in avoiding the sleep. Now, uh, coming to a very important point here, we are now going to discuss tribunals. But before that, a couple of questions that came from the topic. Very easy and very simple to understand. Judicial legislation, judicial legislation, meaning judiciary trying to make laws. Activism is antithetical, opposed to the doctrine of separation of powers as envisaged in the Indian Constitution. Right? So, the judiciary trying to encroach upon legislative functions is actually opposed to what is mentioned in the Constitution, or what is the essence of the Constitution as separation of powers. We agree. In this context, meaning what is the context? That judicial activism actually violates separation of powers. We fully agree. In this context, justify the filing of large number of public interest petitions, meaning PILs, praying for issuing guidelines to executive authorities. So, when it comes to guidelines for executive authorities, we have to justify why PILs are required. Very simple. Justification for activism. Why is activism needed? So, in the intro, talk about activism, but prefer using the word judicial legislation. In the body, mention points like when it comes to these issues, yes, there are some concerns that people raise. So, concerns, but then move on to justify, meaning the pros when it comes to activism. What's the positive of activism? What's the positive of activism? Now, here give as many examples as possible of PILs, including the old examples, the landmark examples, and some current examples. There should be a healthy mix, one or two old and three or four current examples. And in the conclusion, mention how we should avoid what? Overreach. So I had mentioned just before the class ended, prior to lunch, what are the pointers, like say no to judicial governance, etc. Limit yourself to only analyzing the rationale behind policies, don't criticize the other organs too much, refrain from making casual remarks, off the cuff remarks in open courts, which are subject to misinterpretation, all such things. Right? Okay. So now coming to the next question. This was the Azhar. Don't worry, there will definitely be some rain. Anyway, so coming to the question asked last year, the most significant achievement of modern law in India is the constitutionalization of environmental problems by the Supreme Court. Constitutionalization of environmental problems, meaning discuss this statement with the help of relevant case laws. What has been the Supreme Court's contribution with respect to environmental concerns? How has the Supreme Court, through so many PILs, ensured that the environment is clean? Right? So, again, the PILs on environment. So, very simple and easy to understand. Just a sec, guys. Okay, so that's how you write the answer. Just mention all those in the introduction. Talk about again the Supreme Court in recent times through activism has been playing a very proactive role in various areas of administration, including environmental concerns. In the body, talk about the importance and also of activism and give the PILs that we have seen for environment. And in the conclusion, again, the same old story. However, avoid overreach. Yes, Gaurav, every possible kind of case that you know, you can mention there. The case story is not required, just the conclusion is required. Clear? That's it. So easy questions, nothing much to worry. But yes, you have to know all the points plus all the examples quoted in the class so that you can write a comprehensive answer. Now, let's move on and understand tribunals. What are tribunals? So, firstly, tribunals are semi judicial bodies, quasi judicial body, semi judicial, quasi, semi. Now, what is a quasi judicial body? A quasi judicial body or a semi judicial body is almost a judicial body. It's like a court only, but does not, because this quasi judicial body performs similar kind of functions that the court performs, but not all those functions. So, functions resemble that of court of law, resemble, meaning they will conduct hearings, they will make findings of facts, they apply the laws in the country, and they draw conclusions. Courts also conduct hearings. Courts also make findings of facts. Courts also apply laws. Courts also draw conclusions. Eventually, the purpose is to resolve the disputes. Clear? Now, there are various types of bodies which can be quasi-judicial. They can be statutory bodies like NHRC, the Human Rights Commission. They can be regulatory bodies like SEBI, Securities Exchange Board of India. They can even be a constitutional bodies like Finance Commission. All these are examples of what? Quasi-judicial bodies. Bodies which perform functions which are very similar to that of court of law. But these bodies have a point of difference. They are not judicial because they cannot give you certain types of punishments. They need not follow the procedures that are followed in court, like the CRPC, CPC, Indian Evidence Act. Nothing. You don't have to hire a lawyer to go and sit here, file a case here, etc. In fact, the parliament also acts as a quasi judicial. Tell me, when does parliament act as quasi judicial? Any example? Very good. Niranjan, Ravi, Khambapati. Example would be Article 61, Article 67B, removal of judges. So, first two are the very good examples of how the parliament acts as a quasi judicial body, because it is here where the parliament performs all these functions. All these functions. Akash sir, when will you discuss center state relations? Center state relations in the next weekend, and fundamental rights next to next weekend. Clear now? So, tribunals are quasi judicial bodies. Now, in our country, we did not have the concept of tribunals. Though, if you say, but sir, was the word mentioned in the constitution? If you ask in that extreme sense, yes. If you look at Article 136, we saw yesterday only, Article 136, there this word is mentioned, right? And if you read that article, you will find that Supreme Court has the power. What's the power of Supreme Court? Supreme Court has the power to accept SLP, special leave petition, right? Meaning, uh, any case, any matter pending before any court or tribunal, that can be appealed in the Supreme Court. So, in that sense, yes. But there was nothing mentioned on whether we should have a tribunal or not, what will be the membership like, what will be the functions performed. In that sense, no. So, actually, in 1976, via 42nd Amendment Act, based on the recommendations of Sardar Swan Singh Committee, based on this committee's recommendation, the Indira Gandhi government modified the constitution, added a separate part. Which part? Part 14, capital A. Okay? Like part 5. What is part 5? Union. Part 6, states. Part 9. What is part 9? Part 9 of Indian constitution contains what? Very good. Part 9 contains panchayats. Part 9A contains municipalities. Part 14A contains tribunals. And we have two articles, Article 323 capital A and 323 capital B. These are two articles which were added. What were these articles? We'll come to it shortly. And nothing unique. In fact, Justice J.C. Shah Committee 1972, the 58th Law Commission report in 1974, they had all said that we should create some tribunals in the country. Right? In fact, the first ARC 1966 also recommended, let's create a civil service tribunals. And not just this, in 1924, there was this Justice Rankin, Rankin. Justice Rankin Committee had also recommended that we need to create some kind of bodies which can help in solving the pendency of cases in the court system. 1924, Justice Rankin Committee also made the suggestion. So, this was nothing new to us when it comes to tribunals, because a lot of commissions and committees had recommended already that we should have tribunals. Now, uh, how would you differentiate between a tribunal and a regular court first? So, as I said, regular courts believe in controlled fact finding, controlled application of laws. Regular courts follow CPC, follow CRPC, follow Indian Evidence Act, etc. They follow all the proper rules and regulations. Tribunals are authorities outside the court system, which interpret and apply the laws when the acts of government are challenged through formal cases or other established methods. So they just apply laws whenever there is any problem that you face vis-a-vis the government or any law in the country. Now, tribunals are, as we discussed, quasi-judicial bodies. Tribunals are not a court of law, even though they enjoy some of the powers of a civil court. What's the power of a civil court? Two important powers of civil court. Power number one, any body which has been given the same power as that of a civil court, that body has the power to call anybody to be a witness. So if a tribunal is called a civil court, then the tribunals can order us and we have to come and be a witness in a case in tribunal. Number two, the tribunal can ask any private or public body anywhere in the country to submit any kind of document which may be required for them to solve a problem or give any kind of award. So, giving orders to asking people to appear as witness, giving orders asking people and government organizations to what? To submit any kind of records, documents, etc. These are the features of a civil court, and tribunals are civil courts. Then tribunals are free. They are free from Indian Evidence Act, free from Code of Civil Procedure. They don't need to do all this drama. They all they need to do is simply apply the PONJ, Principles of Natural Justice. That's it. Beyond that, not at all. Right? Nothing there. Now, one more thing. Let me just clarify one thing here. uh, Tribunals, a classic example of a body which becomes a tribunal is this point only. If any body provides, applies laws, solves, resolves disputes, gives award, and follows rules and regulations, it is actually a court. If it does not follow all these rules and regulations, it is a tribunal. This was said by Supreme Court in the P.N. Sharma case, that this is what makes a body a tribunal, that it is free from all these rules and laws that need to be followed by the regular courts. Clear? Now, one more question. Since you now know what is a tribunal, please tell me, uh, all tribunals are courts. Yes or no? 10 seconds. All tribunals are court. A for yes, B for no. I'll again bring you here and let's now follow this properly. This is a body which performs the function of conducting hearings, making findings of facts, applying laws, drawing conclusions, resolving disputes. Tribunals. Tribunals. Now, next question is that when it comes to certain types of tribunals, those special types of bodies have to follow CRPC, CPC, Indian Evidence Act properly. So, these bodies follow all the rules, regulations strictly. These bodies are known as courts. So, all courts are tribunals. All tribunals are not courts. All courts are tribunals. Not all tribunals are courts. Supreme Court in the Kyoto Holohan case 1992. This will further help you understand this distinction. Okay, so that's it with respect to the tribunals. So tribunals have all the trappings of a court, but of course they are not courts in the true sense. It's a very generic word, tribunal. Courts are specialized bodies, right? That's it. Now, next point is, why do we need tribunals? And one more thing, tribunals can review their own decisions. Clear? Tribunals can review their own decisions. Now, what are the factors that resulted in the rise of tribunals in the country? See, first factor was courts lack expertise in various areas. For example, in the area of environment, this body NGT, National Green Tribunal, TDSAT, you can Google search for the full form, Telecom Disputes Settlement and Appellate Tribunal, TDSAT. Environmental concerns, telecom concerns. See, government's growing commercial ventures, expansion of its activities have resulted in lot of technical nuances creeping into the system. So, increasing technicality of governance requires experts to be a part of a dispute resolution body, which is a tribunal. Then, tribunals don't follow all the rules, regulations. You don't need to hire lawyers, etc. All the drama is not there. So, it's very cheap. It's fast also. It's inexpensive. It's quick. And of course, the ultimate agenda is to provide relief to all these ordinary courts. That's also there. Now coming to tribunals in our country. So as I said earlier only, we did not have the concept of tribunals, no, of course, in the constitution. Though, if you ask me, sir, what was the first ever tribunal? So I will say that the first ever tribunal was in 1941, and that was the income tax appellate tribunal. First ever tribunal. But anyway, now we have tribunals in Karan, Antriksh versus Independence TV dispute. Yes, yes. So these are very technical matters, and any kind of technical matter which is slightly challenging for judiciary to solve directly is better solved by a tribunal. Then Article 323A, tribunals for administrative matters. So here we have tribunals for administrative matters under Article 323A. So let me just clarify a point here. Through the amendment of the Constitution, one article was added, 323A, which allows the Parliament, understand, it allows the Parliament to create a tribunal. It does not create a tribunal. Can be created by Parliament by law. Are we clear? These tribunals can be created by law for administrative matters. I'll discuss shortly what this means. Then Article 323B talks about, again, such tribunals on other matters can be created by Parliament or even state legislature. So they use the word appropriate legislature by law. Tribunals on other matters. What can be other matters? Land reforms. Other matters can be environment. Other matters can be food. Other matters can be taxation. Other matters can be industrial disputes. Etc. All these are other matters. Now, these two articles allowed the parliament and the states to create tribunals. Did not actually create tribunal. So finally, in 1985, Rajiv Gandhi government came to power. It said we will create tribunals. So under the provisions of Article 323 capital A, that's where they drew the authority and passed a law called Administrative Tribunals Act 1985 to create tribunals for central government, for state government, and for joint services also if required. So we now have a CAT, Central Administrative Tribunal at central level, and this is for central government employees, people like you who will be hired by the central government. SAT for state government employees. Some of you here who will not clear UPSC but will clear the state PCS examination, you will be approaching the SAT. And if there is any kind of a joint PCS which is not there, then JAT can also be created. Clear on this? CAT and SAT. So, what's the purpose of these two bodies? Deal with disputes and complaints with respect to recruitment and conditions of service. With respect to recruitment, conditions of service of civil servants, when it comes to your appointment, if you have any problem in the appointment, okay, appointment, any problem in your salary, any problem with your promotion, any problem with your retirement, any problem with your transfer, you can approach the CAT or SAT. For example, recently, because the CSAT was very tough for some students who did not want to study properly but were just crybabies, they went to complain to CAT. Remember this case where the UPSC aspirants went to CAT to complain that this year only, that the examination was tough and all this. Gaurav, sir, is secretariat same as tribunal? Secretariat? Secretariat, Gaurav, Sachivale, is an administrative building. So that is where administrative work of the government takes place. Secretariat. For example, when you are approving a project, paperwork is required, administrative process is required to approve a project, etc. Right? So that is a place called secretariat, which is the administrative wing of the government, where all the paperwork is done. It has got no relationship to tribunal. Secretariat is a part of executive only. Okay, it's just an office where the paperwork is done. Are we clear now on CAT and SAT? Everybody? Any doubt? No doubt. So this is for CAT and SAT. Now let's move on to understand who are the members of CAT. CAT comprises of chairperson, CAT comprises of vice chairperson, CAT has judicial members, CAT has administrative members. Qualification. To be a member of CAT, you have to be a former or sitting judge of High Court. To be a judicial member, you have to be a former or sitting judge of High Court or secretary for at least 2 years in the Government of India, or additional secretary for at least 5 years in the Department of Legal Affairs. Simple qualification. And to be an administrative member, you have to be a secretary in the Government of India or Government of State for 2 years or additional secretary for 5 years. So basically, lot of these people are IAS officers, largely retired IAS officers. Then appointment by the president in consultation with the CJI. for CAT and governor for SAT. This consultation is not binding and all. Okay. Term of office. Chairperson's term is 5 years or 68 years. Member's term is 5 years and 65 years. One more point. They are debarred from further employment under the Government of India, Government of State. Karan, we don't have a JAT, but in the case of JAT also, the appointment is done by the president only in consultation with the governors of the states involved. Clear? Conditions of service, meaning salary, allowances, etc. Same as High Court judge. And removal. So, how are the CAT members removed? A very interesting provision. Look at this. Members of CAT can be removed by the president only. Members of SAT can be removed by the president only. But after inquiry by Supreme Court, there is no voting. You will complain against a member to the president. The president will send the complaint to the Supreme Court. Supreme Court, please inquire what's the problem. Supreme Court will perform their own in-house function of inquiry. Once they inquire, they send back the report to the president. Sir, my lord, oh sorry, sir, ma'am, this is a report. We feel that the person is corrupt, removed. And the president says, okay, thank you, Supreme Court, removed. So this is a process of removal where no voting is required. No voting. It is just inquiry by Supreme Court. No voting in the parliament. So, of course, CAT and SAT members, UPSC, SPSC members, CIC, SIC members, CVC, Lokpal, NHRC, all these people have the same process of removal that is used to remove the members of CAT and SAT. Same process. Inquiry by Supreme Court. There is no parliamentary voting for removing these people. Are we clear on this? So just mentioning it here so that you can remember all of the points collectively mentioned at one place only. Muskan, tribunal and PIL difference? How can you differentiate between these two bodies, these two things? Tribunal is a body, PIL is a court case. How are you even comparing? How to differentiate? I mean, PIL is a case. When you file a case in court, it's called a PIL when you have no relationship with the affected person. That's called a PIL. Tribunal is a body where cases are filed. So a difference can be between a tribunal and a court. But how can I differentiate between a PIL and a tribunal? It's like asking what's the difference between bread and member of parliament. Same kind of thing. They are two different things, no relationship only. Anyway, now I have mentioned all these things, but let me also write to you. These are all these old provisions. Now you will say, if these are old provisions, then why have you mentioned here? Did you not update the slide? We'll come to it shortly. Why I have still mentioned it here despite being old provisions. Now, one very important point. Back in originally, the awards given by tribunals were not challenged in any court. Okay, except Supreme Court. When the tribunal, CAT, SAT, gave any kind of award, it could only be challenged in the Supreme Court. In 1997, L. Chandrakumar judgment, Supreme Court said that, see, how dare you? How dare you bypass my high courts? High courts are also court of records. You cannot bypass high courts. So every tribunal's award or decision can be challenged in the high court also. So now, case filed in tribunal, and then if you don't like the judgment, first appeal, high courts, final appeal, Supreme Court. This is the hierarchy of movement in a case. So since the L. Chandrakumar judgment, now the cases come back to the what? Supreme Court, high courts. So the tribunals were actually supposed to unburden the already burdened judiciary, but because of the L. Chandrakumar case, now the high courts are the places where tribunals can, the awards of tribunals can be challenged. Clear? So in any case, in future, you are a civil servant and things go wrong. The minister is harassing you, disturbing you, transferring you. You complain to CAT. Let's hope, firstly, that you never get to complain to CAT. Because let's hope that your entire civil services career remains impeccable. No fingers are raised on you. That is not possible. That is only possible if you are blatantly corrupt. So don't worry. If you are doing the right thing, you need not worry. You will start worrying only when you don't do the right thing. Those sleepless nights come only when you take money, you are corrupt. But yes, if you have not been given promotion, etc., you approach the CAT, file a complaint there. The CAT decides. If it decides on something and you don't like it, you can approach the High Court also, Supreme Court also. Clear? But again, the whole point is you are filing a complaint in CAT, which largely comprises of civil servants. What kind of award will they give? Then the case goes to High Court. You're filing a case against the government. Even if you win the case, you come back and work in the same government. I'm not sure whether the government will be equally cooperative with you after this. That may not be the case. But one very important point that will serve you in your entire UPSC career is the point that just do one thing. Don't be afraid of transfers. I know there'll be some situations where, especially right now, you are young, no burden, not married, no kids, no spouse, you're free. But when you get married, kids, spouse, you would likely want them to be in a city with good atmosphere, good studies, good schooling, etc. And you are posted in some remote area. So, of course, transfers are very important. But it is said that if a civil servant is not afraid of transfers, then you are free to work. So, only if you are free from the clutches of this fear of transfer, you can thoroughly enjoy and actually contribute to governance. So, that's one thing you should have. Get it instilled, right? And otherwise, see whether you are posted in the National Archive Department or the Ministry of Finance, you have the same allowances, you have the same bungalow, same resources. So it does not really matter. What will matter is the opportunity. So maybe if you are posted in a very important ministry, a lot of people come to you and meet you, etc. If you're posted in some other ministry or department, that may not be the case. But again, it's all for a very small period of time. That's why we always say in your civil services rule also it is mentioned in your governance class we'll be studying this, that you have to always have the role of impersonality. Never be too attached to the post, because people who come to meet a civil servant, they don't love the civil servant. They respect the post. And in most cases the civil servant gets confused that they are respecting me. No, no, they are not. Who are you? You are just a person who has been temporarily given a charge to manage a very important position of being an SP, DM, etc. If you are replaced, people forget you. So you have to develop this role of impersonality. Never be too attached to your post. Anyway, now coming to what are the advantages of having tribunals in the country. Advantage number one, flexibility of procedure. No rigid procedures. Indian Evidence Act has to be followed. To give you an example, I think the movies they always show this, that the court case is going on. Suddenly, the entire court is stunned. Why? Because a witness comes in the court. The entire court looks at the back. Oh, who has come? And a witness walks in and changes the history of the entire case only. And the hero wins. Right? These things don't happen in reality. You're not allowed to surprise the court. That court, surprise, witness. No, no, no. If you want to present any evidence, any witness, you have to inform to the court prior and to the other party also that I am going to submit this evidence. Please take a copy, read it. Clear? It's all to be informed. So these are limitations, right? Here, no limitation. Flexibility of procedure. All that you have to do is follow what? PONJ. Principles of natural justice. That's something you need to follow. Then, because they are cost effective, time effective, they provide efficiency in giving justice, quick and fast. They are unburdening the judiciary. And of course, keep a check on pendency. And then specialization through expert involvement. There is also this case of tribunals comprising of experts who are experts in that field. This would mean that a tribunal can give a more accurate, can have a more accurate understanding and can give a more appropriate judgment or an award in a case or matter before it. So, expert involvement. One more thing, tribunals also have the power to punish for contempt. That's also there. For example, if a cat gives an order and that order is not followed, cat can punish you for not following the order. That's there. Are you clear? But then come the problems. So, what are the problems? As far as the problems are concerned, see, one problem that people have raised time and again is that these tribunals is a way in which the governments want to encroach upon the functioning of the judiciary, because directly you can't interfere, so indirectly you're creating tribunals to interfere and encroach upon judicial functions. So one big argument has always been of this tribunalization, that is encroachment of judicial functions. Tribunalization. Now, first things first, delay in the disposal of the cases. Sadly, we have too many people. So you can never make this claim that, oh, tribunals, there is no pendency. There is pendency everywhere. In the tribunals also, there is pendency. Just to mention this point, uh, in a body, in a like cat, in cat there are around 17,000 some, so roughly around 17,000 cases are pending. Income tax appellate tribunal, in the income tax appellate tribunal, 92,000 cases are pending. In the railway claims tribunal, RCT, railways claims tribunal, 46,000 cases are pending. In DRT, Debt Recovery Tribunal, DRT, 78,000 cases are pending. So, sorry, but pendency is something that will be there everywhere because of high population. Don't ever think that we can escape the clutches of pendency in the country. Here also. Then, violation of separation of powers. A very good example is this body called NGT. Now look at NGT. You'll be studying about this body more in your environment classes. NGT is a body whose task is what? The task, see, the purpose of NGT is to have effective and expeditious, fast, quick disposal of cases relating to environmental protection and conservation of forests and other natural resources, right? So it largely helps in curbing any kind of environmentally damaging activity, right? And Supreme Court also said that NGT is a complementary, competent, and specialized forum to deal with all environmental multidisciplinary issues. Now, NGT makes its own rules, right? Which work like laws in the country on what needs to be followed, like a legislature makes those rules. NGT also implements rules. In fact, every law that you can think of which relates to environment is implemented by NGT. For example, the Water Protection and Control of Pollution Act 1974, the Water Prevention and Control of Pollution (CES) Act 1977, Forest Conservation Act, Air Prevention and Control of Pollution Act, Environment Protection Act, the Biological Diversity Act. Every such law is implemented. Implement laws and rules. Barring, I think, two laws that you can think of. One is this Wildlife Protection Act. That is not under NGT's control. And the Scheduled Tribes and Other Traditional Forest Dwellers Act. That is not under NGT's control. Otherwise, every other act relating to environment is implemented by NGT. You make rules, you implement rules. And if you do not follow the guidelines of NGT, then NGT can impose punishment also. Penalties and punishments, which can be up to 5 crore rupees. Sorry, not 5. Up to 10 crore rupees or up to 3 years jail. Jail sentence, fine can be imposed by the NGT. All the LEJ functions performed by one body only. And one more thing just about NGT, a short note here. Awards of NGT can be challenged only in the Supreme Court. Are you clear? Unlike all other tribunals, NGT's awards can be challenged only in Supreme Court, not in other courts. That's not possible. Clear? That's one problem. Then independence is compromised. Yes or no? Example. Look at members of CAT, members of SAT. They are all civil servants. As a civil servant, you owe your allegiance towards the government. If I am going to a CAT and filing a complaint in front of a CAT bench, right, then those civil servants there, they are more likely to side with the government for some future benefits, etc. Then allegations of corruption. That is there in everybody. In fact, we have seen recently also there's a case in Maharashtra. I think Nagpur bench of CAT was involved there, where one person complained that he wanted to get his pension released or gratuity released, and one of the CAT members told him that pay me 50,000 rupees and I will release your gratuity immediately. I'll give the order in your favor, which will force the government to give you your gratuity or pension immediately. Direct demand for money, right? So allegations of corruption. Then vacancies and delays in appointment. That's a standard problem everywhere. For example, in CAT only 42 out of 69 seats are vacant. I mean, 2/3 seats are vacant. That's a vacancy in CAT. And lack of infrastructure. Opaque. In fact, not just this, lack of infrastructure plus poorly maintained websites, regularly not available, non existent, unresponsive, not updated. These are some of the terms we can use with the websites of these tribunals, right? So, these are all the problems pertaining to our tribunals in the country. Clear? Now, in 2021, originally an ordinance was brought. Later on, a proper law was made because every ordinance has to be replaced with a proper bill. So it was done, and that is called the Tribunal Reforms Act 2021. See, the government said that there are a lot of these tribunals in the country where nobody complains. People have this habit of going to High Court. They never go to tribunals. They simply bypass the tribunal. So why to have these tribunals? Cancel them. Cancel all of them. And whatever is the pending cases in front of these tribunals, send them to the High Court. So this Tribunals Reforms Act dissolves certain existing appellate bodies and transfer their functions, meaning adjudication of appeal, solving the cases, to other existing judicial bodies like High Court. For example, Airport Appellate Tribunal, Appellate Board, AAR, FCAT, all these have been abolished, and any pending case is all sent to High Court. So here, if you have any kind of pending cases, they are all now sent to corresponding High Court. Okay, clear? That's it. Apart from this, some other changes were made under this law. Changes with respect to appointment of the members and their conditions of service. So now the appointment will not be done directly by the president on the advice of Chief Justice, but will be done on the by a search cum selection committee. Search cum selection committee, SCSC. This committee will comprise of Chief Justice of India, two secretaries chosen by the central government, sitting or outgoing chairperson, or retired Supreme Court judge, etc., and the secretary of the ministry under which the tribunal is there. So basically, they have no right to choose, but these four people will choose. Clear? Now, this committee's task is to find out people and recommend those names. The government will take up these names, and vacancy, for every vacancy, this SCSC, Search Cum Selection Committee, will give two names to the government. Government can choose anyone and appoint the person. The committee shall forward two names for each post, and the government would take a decision within 3 months. But look at the word here. The government will take a decision preferably within 3 months. What's the meaning of preferably? If you say, I ask you, will you write the answers next week? You say, sir, yes, I will write the answer preferably next week. What does this mean? Never. In your case, it means never. Same thing here. What is this preferably? Why, we are giving you names, right? So, ideally 3 months, but not binding. We may not choose. Then what's the point of giving names? I mean, we are giving you two options for every post. You can choose one. What is a preferably thing? This means that recommendation of the committee is not binding. Then what's the point of recommendation? Right? That's there. Then, very interesting provision. Minimum age of a person to become a member of the tribunal is 50 years. Now, please tell me, we have seen the high courts also, we have seen the Supreme Court also. Did you see any minimum age anywhere? What's the minimum age to be a Supreme Court judge? Tell me. What's the minimum age? No minimum age, right? And what is so magical at 50? That at 40, see, 18 is a minimum age for a lot of things, is a sign of maturity. 21, 25, etc. But at the age of 49, you are useless. At the age of 50, suddenly you are so intellectual that you can be a member of a tribunal. And interestingly, if you observe this point, high court judges normally there is a cutoff age, normally 45. So in most cases, you will find that people above 45 become high court judges. Right. So a high court judge at the age of 47. At the age of 47, 48, 49, you are fit to be a high court judge. And these tribunals awards are being challenged in the high court. So somebody is fit to be at the top but not below because of age criteria. What kind of criteria is this? And also, earlier the tenure was 5 years. Now it is 4 years. Now it is 4 years. And maximum age was 68. Now it is 70. Now it is 67. And look at this. You are now eligible for reappointment. Tenure has been reduced and you are eligible for reappointment. Meaning, if you give judgments in the favor of government, very good. Reappoint this fellow. If not, very bad. Get lost, useless fellow. That's what this means. In fact, not recently, but way back in 1987, there was a Supreme Court judgment, not about tribunals, in general. So, Supreme Court in the SP Sampath Kumar case had said that whenever you reduce the tenure of any important functionary, you are compromising on that person's independence. So, Supreme Court said that if you reduce the tenure, you actually are violating independence of the post, and had said that there should be longer tenures for important positions. Sadly, if you make these changes, they actually violate the Supreme Court judgment also. Anyway, as I said, originally this entire concept of tribunals was brought through an ordinance originally. And then the ordinance was, when it was brought, that ordinance was immediately challenged in the court. Madras Bar Association challenged the ordinance. Said, what nonsense is this? And you'll be surprised to know that whatever I have mentioned or underlined in blue was all struck down by Supreme Court. The provisions of the earlier ordinance. Here, this also. Struck down by Supreme Court in the ordinance. So ideally, when the government had to bring a bill on this topic, they should have removed these provisions because these provisions were cancelled by the Supreme Court. But the government said to hell with everything, and they brought the exact same provisions again. Exact same provisions were brought again, right? The provisions with respect to tenure and minimum age, which were introduced via ordinance, were struck down by Supreme Court. But the government paid no attention to this. They said, we are bringing the same proposal. Simple. And they got it passed also. Majority. They got it passed in the parliament. Again, this matter has been challenged. But how can you do this? The Supreme Court is yet to decide whether the Tribunal Reforms Act is unconstitutional for reenacting the provisions that were struck down in the Madras Bar Association case for violating the independence of judiciary. This case is pending. And what are the issues? Short tenure, issue number one. If tenure is very short, it increases the influence and control of the executive. Minimum age of 50 years, it's a restrictive qualification. What is so magical at 50 that happens? And when you are abolishing certain tribunals, you are only going to increase the workload of the high courts. So these are three issues. And let's see what's the Supreme Court order. If the Supreme Court order comes, then the old provisions will come into picture. If not, they are cancelled. That's why I mentioned the old provisions also, so that in case the Supreme Court's new provision kicks in, please make sure that you cancel the old ones, tribunal reforms new provisions, or if the Supreme Court cancels the provisions, the new ones, then the old provisions come back to life. Did we understand this concept of Tribunal Reforms Act, or have we been sleeping so far? How many of you had a sound sleep? Tell me quickly. I know Article 21 allows every individual the right to sleep. So I don't want to interfere with your fundamental right, but let me tell you, it could be detrimental. In the exam, you cannot quote, my fundamental right to sleep was there, so I kept on sleeping in my coaching days. Okay, great then. Uh, a simple question for you to solve. How far do you agree with the view that tribunals curtail the jurisdiction of ordinary courts? In view of the above, discuss the constitutional validity and the competency. What is competency? Advantages plus issues with respect to the tribunals. So normally we write intro body conclusion, but this question I'll give you an alternative way to write the answer. Use the three paragraph approach. Paragraph 1, paragraph 2, paragraph 3. What is para 1? What should it contain? Para 1 would contain the point that how far do you agree? This means the issue on tribunalization. Do you think that because of tribunals, the ordinary courts have lesser power now? Not really. After especially the Chandrakumar case, it is no problem, right? Second paragraph, focus on the constitutional validity. And number 3, competency. Use this to write the answers. Different kind of structure from what you are normally used to. In a paragraph approach, there is no need to have equal weightage to all paragraphs. The weightage depends on the question. So here it could be, since it's a 250 word question, there could be 100 to say 120 words here, around 60 words here, and again remaining 80-90 words here. Okay, are we clear? This is how you can follow. That's also a very interesting way to write this. So I'm just giving an example here. It's up to you to have this word limit. So there is no need to have equal weightage to all the three paragraphs. So please try this structure also to write the answer. It looks nice when you can mix and match various structures in your paper, because everybody keeps on writing the same old intro, body, conclusion kind of approach. Sometimes we have to also give a fresh perspective to the answers. Okay, that's it. Done. Let's now move on and understand the important articles. Firstly, in case somebody is following Lakshmikant, then what is required? Chapter 26, Chapter 27, Chapter 28, Chapter 29. Then we have 30, 31, 32, 33 are Governor, CM, Council of Ministers, and State Legislature. Then 34, 35, 36. 34, 35, 36. Okay. Now, important articles. What important articles? Right from Article 124, 124, 129, 131, 136, 137, 139 capital A, 142, 143. Also, I would mention here only uh, Article 32, but we'll discuss that again later on. So, then 217, sorry, 215, 217, 226. Then also moving on to the subordinate codes, 233, 234. Then, very important, Article 121, 211. The conduct of judges can't be discussed in the legislatures. Yes or no? And then lastly, these two articles, 323 capital A, 323 capital B. That's it. These are the important articles. Others content is sufficient. Focus on these articles and know that should be enough. We have not studied any schedule. Important cases. All the judges' cases are important. Okay. So judges' cases 1, 2, 3, and the fourth one also. First, second, third, and the fourth. And then PIL examples. As many as you can remember. That's totally up to you. How many you can remember? Then L. Chandrakumar, 1997, and the Madras Bar Association of 2021. Important cases. Clear? We are done with L, E, and J. In fact, even though it's just half the classes, slightly more than half, we have covered more than half of the syllabus. Now, primarily smaller topics remain, starting with our discussion on elections. We'll move on and understand about union territories, part 1 of the constitution, all such things. So, only smaller topics remain now. And once we are done with all this, we'll discuss interstate relations, emergency provision, schedule 5, 6 areas. And once we are done with the public administration side of events, we'll move on to the political science side of events, where we discuss the rights, DPSPs, duties, etc. Okay. So a large chunk of your discussion, especially the core discussion, is over. The other core that remains is that of center state federalism and rights. So please revise now adequate number of times. Clear? Let's take a break. Let's not harass you too much. So take a break. Be back at 3:45, and we'll continue our discussion further. Okay, break please, guys. Welcome back, guys. One more small session, and then we'll begin our journey to the evening break, snacks time. So, now, next topic is elections, right? First up, some basic information on elections. I hope that all of you are focusing only on the PPT and not watching the match, despite the fact that India is very comfortably placed. Please focus on the discussion at hand. Don't watch the match. Sacrifice so that in future you can make this statement. I sacrificed India Pakistan matches and then studied. How else will you tell your kids these amazing stories of success? Anyway, so firstly, some basic provisions with respect to the constitution. See, when it comes to any kind of law being made by the parliament on elections, of course, we know that parliament is a competent body which is allowed to make laws on all matters dealing with elections to either house of the parliament or the state legislatures. Of course, that's something which is a given, that yes, parliament can make laws. However, what's more important is to understand that even states can make laws. State legislatures can also make laws with respect to matters related to elections for state legislature, not parliament, but for state legislature. But on aspects where center has not made any law. I'll explain this point. Let's think of this. For the elections pertaining to parliament, for the elections pertaining to state legislature, two things. Number one, if with respect to the parliament, laws have been made by the parliament on say 5 topics: topic 1, topic 2, topic 3, topic 4, topic 5. Correspondingly also, laws have been made to conduct elections for state legislature on topic 1, topic 2, topic 4, topic 5. One area is blank, meaning this area is where there is a law at the central level to deal with elections, but there is no law at the state level. On these matters, state legislature may make laws, meaning overriding laws can't be made. But if the parliament has not made a law on any topic, then the states can make laws. So I don't expect UPSC to ask this complicated statement, but if a simple statement is asked, state legislatures can make laws on matters governing or dealing with elections. Yes or no? Yes, they can make laws. Can those laws violate the parliamentary law? No, that's not possible. Clear? Then, of course, one very important point that you need to understand in our country is this idea of something that you would know already. Back in the days of Morley Minto reforms, remember the dangerous Morley Minto reforms, which talked about what? In 1909, what was introduced? Very unique provision. To further divide the country. No response. The system of separate electorate. Do you remember? Separate electorate. What is the meaning of electorate? Electorate refers to voter. separate voter list. Separate voter list. Now, under Article 325, as per the Constitution, it is very, very clearly mentioned. There is no provision for separate voter list in our country. Extremely sorry. This is something we cannot allow. There is no provision for separate voter list on the grounds of religion, on the grounds of race, on the grounds of caste, on the ground of sex. So we cannot have a separate voter list. Only Hindus will vote, only Muslims will vote. We cannot have a separate voter list. Only men will vote, only women will vote. All this drama is not there. But only on these grounds. On other grounds, possible. Can you tell me, is there any other criteria which disqualifies you from being a part of voter list? Age, citizenship, yes or no? In case of MLCs, graduation, right? Education qualification. So tomorrow, we can have a voter list which is based on literacy levels. It's possible. Yes or no? Tell me. Tomorrow we can have a separate voter list which is based on educational qualifications. Does the Constitution allow for this? No? Yes, it does. The Constitution only does not allow voter list on the basis of four things. On other grounds, you can have a voter list. There is no problem. You can have a voter list on the ground of education also. Tomorrow, there can be a law that from now onwards, fifth pass will be allowed to vote. It's possible. Are we clear? Okay. In fact, currently also, education is a ground to vote for MLCs. Yes or no? It's still there. And then Article 326. This is the most misunderstood article, sadly, because people largely believe that this article is the article for what? This article is the article for right to vote. This is not the right to vote. This article talks about UAF. What is UAF? Universal Adult Franchise. UAF. With minimum age being 18. This article says that, or rather, gives the right to be a part of electoral rolls. This article only says that every citizen above the age of 18 has a right to be a part of electoral roll. What's the meaning of electoral roll? Voter list. That's it. It does not give you the right to vote. Right to vote comes from some other place. I will tell you shortly from where does the right to vote come. Don't worry. Okay. So these are some constitutional provisions, but now let's move on to understand a more important element, and that element is going to be the body Election Commission of India, ECI. This is a constitutional body, Article 324, and we have the Chief Election Commissioner Rajiv Kumar, retired IAS officer, Bihar cadre. We have Shri Anup Chandra Pandey, who is also retired IAS officer, Arun Goel. All these three retired IAS officers. Motivation for today: if you clear the exam and become an IAS officer, even after 60, you still have these posts open, right? This is today's motivation. That please study hard, clear the examination, and even after 60, you can still be an election commissioner, chief election commissioner, etc. First up, appointment. How are the election commissioners' appointment done? Election commissioners' appointments are done by the president, subject to parliamentary law. So, until and unless Parliament makes a law, the election of the appointment of the election commissioners is to be done by the president. By the president. Till the Parliament does not make a law, this is the provision. So, basically, the Council of Ministers will directly appoint the what? Election commissioners. Second thing, mind you, all this is mentioned under Article 324, Clause 2. The appointment. Now, including composition, same thing, same article. Uh, See, as far as ECI is concerned, this body was set up on the 25th of January 1950. ECI. And that is why since 2011 we celebrate what? What is 25th of January celebrated as? No idea. Yes. This date is celebrated as the National Voters Day. Republic Day? Arey sir, focus here, not the math, sir. 26th, no, 25th January. Don't give me heart attack, sir. Please. Okay. Now, what is the composition of the election commission? Meaning, how many members? So, the election commission shall consist of a chief election commissioner. Done. And such number of other election commissioners, if any, not mandatory, if any, as the president may from time to time fix. So basically, what's the composition? One CEC. Who is a CEC? Chief Election Commissioner. Plus, how many other election commissioners? Tell me. X number of election commissioners. And who decides this? To be decided by the president. Here X is a variable, not the X you are thinking of always, please. So, currently, one CEC plus two ECs. This is the current situation. But as per the constitution, How many election commissioners? That number is not fixed. Clear? Now, what is the qualification? Nothing is mentioned. Nothing is mentioned in the constitution with respect to qualification. One thing is that their service conditions cannot be varied to their disadvantage. That's one point there, that the service conditions can't be modified to their disadvantage. But anyway, now, what is a tenure and what is the age of retirement of election commissioners? That is not mentioned in the constitution. Am I audible to everybody? It is not mentioned in the constitution. It is mentioned in the Election Commission, Conditions of Service of Election Commissioners, and Transaction of Business Act 1991. As per this law, the salary is the same as that of Supreme Court judge, and the term of office is 6 years or 65 years. Are we clear? Not as per constitution. Okay? And let me just clarify here. CEC, ECs all get the same salary. And what about the power? So here, all decisions majority vote. This means CEC and ECs have equal powers. Shabir, sir, 6 to 65. Sir, it is this 6 years is the tenure, and this 65 is the age of retirement. How will this happen, sir? From 6 to 65. So 6 years is the tenure and age is 65, whichever is earlier. Okay. Now, just to add a point here, in the previous session, which was the previous session of the parliament? Tell me, which was the previous session of the parliament? Which session did we just have in the parliament? The monsoon session. So in the monsoon session, a bill was tabled in the house. It is yet to be passed. Hopefully it will be passed only. I mean, it's just a matter of time. But since it is not passed as per the date of teaching, so I am referring to this as the bill only. Okay. The CEC and other ECs bill. So in this particular bill, the appointment procedure has been given because the parliament has the power to, through a law, create the appointment process. So now there will be a search committee. What's the search committee? Search committee's task is to find out search committee's task was to find out the names of people, appropriate people, from whom the selection committee will pick and choose the best people and make appointment. So this search committee will comprise of the cabinet secretary, the senior most IAS officer, and two secretary ranked officers. Those people who have the knowledge in matters of elections. And this three-member group, see, knowledge in matters of election is nothing unique. Every civil servant come from the root of DM, SDM only. And when you are a DM and all, you have to conduct elections. That is sufficient to say that you have knowledge of election matters. That's it. Are we clear? So when you become the district magistrate and all, you will have to conduct elections in your own constituency. In the Lok Sabha, you are the returning officer. In your constituency, you are in charge of conducting elections. So you will have the knowledge in the matters of election. They will suggest 5 names to the selection committee. This selection committee will comprise of 3 people: Prime Minister, Leader of Opposition Lok Sabha, and the Union Cabinet Minister, who is chosen by the Prime Minister. Are we clear? These 3 people will be a part of the selection committee. Nobody else. No CGI, nothing. No Gaurav, not CGI. Okay? I'll just point out one thing here. LOP in the Lok Sabha is a part of selection committee. So please, innocent aspirants, tell me, do we currently have an LOP in the Lok Sabha? No, we don't. Then what will happen here? So always understand the simple golden rule. Whenever there is a need for the LOP of Lok Sabha to be a part of any committee, okay, and there is no LOP in the Lok Sabha, Mavlankar rule is bypassed. Mavlankar rule is ignored. Meaning, what's the Mavlankar rule? The 10% rule. So you can ignore that. So we'll simply find out whichever party in the opposition has the highest number of seats, whether they follow the Mavlankar rule or not, meaning whether they have at least 55 MPs or not, that party's leader gets the chance to be the member of that committee. That is why the example is Adhir Ranjan Chaudhary, who you will find is a part of all such committees, because Mavlankar rule is always ignored in case there is a need of LOP Lok Sabha, but there is no LOP in the Lok Sabha. Did we understand this point, everybody? He is a criminal, sir. Don't make all these statements, sir, please. Defamation. Parshuram, can you please repeat? Okay, Parshuram, please hear me out. For that, revisions are very important. See, to be the LOP of Lok Sabha or Rajya Sabha, 2 criteria. Number one, you should belong to that party which has the maximum seats in the house, in the opposition. And number two, your party should have at least 10% seats also. But currently, because there is nobody in the LOP, nobody has LOP in Lok Sabha, because nobody meets the 10% criteria, we will ignore the 10% criteria only for such situations, so that that person becomes a member here. This does not mean that he becomes the LOP of Lok Sabha. He only gets the opportunity to be a member here. Are we clear, Parshuram? Gaurav, you should have asked this question in the LOP Lok Sabha. If 2 parties have more than 10% seats, then we'll see which party has more seats. If 2 parties have same seats, then the speaker decides. Okay? Jayanta, sir, you yourself are writing the answer. They have many allegations. Innocent till proven guilty, sir. Innocent till proven guilty. What to do? Harsh reality of life. Anyway, and this selection committee will then, from these 5 people, recommend a name for the appointment to the president. This is how the members of the election commission will be appointed if this bill is passed, which it will be passed. Now, we have now qualification also. What's the qualification? The qualification is now either you are a current or a former secretary ranked officer. Direct qualification, IAS officer. Simple. Best qualification. So, secretary ranked officer, and you have expertise in managing and conducting election, which every IAS, most IAS have, because they have been a district magistrate in their initial days. So they all have the expertise in managing and conducting elections. Now, earlier the salary and allowances were same as Supreme Court judge. Supreme Court judge. Status, honor. Now your salary is same as cabinet secretary. Who is a cabinet secretary? Government employee, IS officer. Election commissioners are now being reduced to the same status as a government employee. And that is not good actually. That is not at all appropriate. That you control the conditions of service of the election commission. Dr. Ambedkar has referred to four pillars of the Indian constitution. Tell me, which are the four pillars of Indian constitution? Supreme Court, CAG, UPSC, and Election Commission of India. And this is what you have reduced the ECI to now. The election commission the election commissioners are now of the same status and rank as a government employee. Full control of the government. Term of office 6 years or 65 years, and they are not eligible for reappointment. Clear? If this bill is passed, this is going to be the new applicable provision. Okay, should we move on now? No doubt. Okay. Now coming to removal. So removal is mentioned under Article 324, Clause 5, which says that the Chief Election Commissioner, I think we know this point, the Chief Election Commissioner is removed in a similar manner to that of Supreme Court judge, meaning special majority voting in the parliament, all the drama takes place. How are other members removed? Nothing is mentioned. The other ECs can be removed, and that removal can be initiated on the recommendation of the Chief Election Commissioner. No process mentioned. Nothing is mentioned. No voting requirement mentioned. No criteria or ground mentioned. Okay, that's there. Anyway, just to point this out, in 2023, there was a case called Anu Barnwal case, which was with respect to ensuring independence of the election commission. So in this judgment, Supreme Court had said that till the parliament enacts a law on the subject, the election commissioners will be appointed by a committee comprising of the Prime Minister, LOP in the Lok Sabha, and the Chief Justice of India. So basically, in the new bill, the government of India has replaced this person only. Replaced with a cabinet minister. In the new bill. Are you clear? Then Supreme Court also said that it is desirable that the ground of removal of the election commissioners shall be the same as that of CEC, meaning both should be removed in the same manner. But in the new bill, the government has not said anything about how to remove the election commissioners. They have shown no interest in that. And number three, the conditions of service of ECs shall not be varied to his disadvantage after appointment. So this is something the Supreme Court has said. This has already been modified. So now the appointment will be done by the selection committee, which will comprise of the PM and a union cabinet minister chosen by PM. Tell me, who will the PM choose? What is your guess? Who will the PM choose? Of course. Of course, his best friend. Who else? The PM will choose Amit Shah or some other minister. Now look at this committee. This committee comprises of PM and a minister. Both are part of government only. 2:1. What's the point of this committee? This committee makes no sense. It is just like appointment done by government only. 2:1. Member of the executive, member of the executive. Yes or no? Anyway, that's the current situation with respect to the election commission, members, appointment, etc. Solve this question. This question came in the year 2002, 20 years back. Let's hope all of you get this right. People who solve this question correctly are joint secretaries somewhere. Oh, a lot of you have made mistakes here also. Uh, okay. The Chief Election Commissioner and other ECs enjoy equal power but receive unequal salary. Yes or no? They receive equal salary. One is wrong. These two are wrong. Two has to be correct. Let's check three. The Chief Election Commissioner shall not be removed from his office except in like manner and on like grounds as Judge of Supreme Court. Absolutely correct. B is the answer. Two statements and you have the answer. The CEC is entitled to the same salary as provided to a Judge of Supreme Court. Absolutely correct. The term of office of election commissioner is 5 years. Wrong. From the date he assumes his office or till the day he attains the age of 62 is wrong on both accounts. Hence, B is the right answer. Clear? Now, coming to the functions performed by our election commission of India. So, of course, the idea is to conduct free and fair elections. In fact, conducting free and fair elections is the constitutional prerogative, the constitutional imperative, right? Supreme Court has said. So, conduct and supervise free and fair elections. Okay? To the Lok Sabha, to the Rajya Sabha, to the Assembly, to the Council, for the President, for the Vice President. Which election is not conducted by ECI? Elections to panchayats and municipalities. That is the local self-governance elections. Conducted by, tell me please quickly, State Election Commissioner. Which article is this? 243 capital K. Okay, State Election Commissioner. Then the task also is to prepare and revise the electoral roll. What's the meaning of electoral roll? Tell me quickly. What is this electoral roll? Voter list. Voter list. These two are all part of Article 324, Clause 1. Okay. Then to fix the election program. This is mentioned under Section 30 of RPA 1951. Fixing the election program. Do you have the UPSC program? Tell me, what's the UPSC program like? In the month of January or February, notification comes out. In the month of May, the first harassment of prelims. In the month of September or October, second level of harassment. In the month of February, March, April, the final selection through interview, and then the result is declared. That's the entire UPSC schedule. Similarly, we have the election schedule also. Who decides that? Election Commission decides that. How? So the election program starts with the announcement of election. Point 1, announcement. As far as this is concerned, announcement is done by the ECI. So by Election Commission of India. Now, once announcement is done, then an official notification is released. Once the notification is released, then the people who are interested can contest elections. So they will start filling their form. This is done by the president or the governor. Once this is done, the form filling date starts. Now, between announcement and notification, there can be a gap of only maximum 21 days. Maximum 21 days of gap, not more than that. And after notification, 7 days of time is there. How many days? 7 days. In these 7 days, you have to fill up the form. Nomination. Just like for UPSC also, the form filling window is open for a few weeks. Similarly, once nomination date is over, then the election commission takes 1 day time to look at your forms that you have filled. So we say it's scrutiny of nomination. Scrutiny of nomination. Then, after this, 2 days of time is given that anybody who wants to withdraw his candidature can withdraw. Just like in the case of UPSC, if you have filled up the form, you are given the option if you don't come and sit for the prelims examination, your attempt will not be counted. Your attempt will not be wasted. So don't sit for the exam. Withdrawal of nomination. 2 days gap. After this, then starts the polling, right? But you have to give the members some time to campaign also. Minimum 14 days time. This is a time when the members campaign. And here, polling begins. So basically, now the voting starts. Finally, after, depending on how large the state is and all this, the polling ends. Once the polling ends, the final step is, of course, the declaration of the result. And then we can choose, or rather, we have chosen who is going to harass us for the next who is going to represent us for the next 5 years. Are we clear on this? This is the entire election schedule that's there in the country, fixed by the Election Commission of India. Any doubts? No doubts? Great. Let's move on then. Please tell me what is the first point here. Please, I really want to know. Which article is this? I want to write some article here, but I want you to tell me what's the number. We have already seen this provision. You will be surprised. Kambapati, very good. Shahid, Ragini, excellent, very good. 3 correct answers so far. This is Article 103. Advising the president or the governor on electoral matters, including the disqualification of the legislators. Okay. Then preparing the model code of conduct, MCC, for parties and candidates. So what is MCC? We'll discuss shortly. Model code of conduct is the guideline of good behavior that is expected from every party and the candidate in the run up to the elections. So before the election period, there is a list of guidelines meant for the people who are contesting elections and the parties in general, and the expectation is that they should follow these guidelines. Then Election Commission of India also runs an institute called triple IDEM. IIIDEM. This is the India International Institute of Democracy and Election Management. This is basically an institute which provides training to election commission officials. Provides advanced training to EC officials of other countries, like say Uganda, Nigeria, etc. Of course, these countries only will come and get trained by us. Western countries are too full of themselves. Anyway, so triple IDEM. Then examine the account of expenditure submitted by the candidate. So whenever you are contesting election as a party, right, as a candidate, you have to submit all the records of how much money you spend during campaigning. Candidates plus political party, or rather parties. Clear? So if it is a Lok Sabha elections, within 90 days of the completion of elections, for the Lok Sabha, and within 75 days of the completion of election to the Legislative Assembly, these people have to submit the election expenditure. How much money have they spent? Clear? Okay. Then it decides the criteria for recognizing parties. So more on this in your governance classes, but just to briefly tell you, a political party which wants to contest elections can be put under two categories. Either you are unregistered or you are registered. Only registered political parties are allowed to contest elections. After contesting elections, some parties get recognized for their amazing performance. Other parties are unrecognized. And even those which are recognized, they are of two categories. One party which performs very well across the country is called a national party, and parties which perform very well in some state are called state parties. This is how you classify political parties. Just like you as a civil servant, think of the same example. All the civil servant, all the aspirants, those who fill up the form are registered now. Those who don't fill up the form, unregistered. Nobody cares. Those who fill up the form and take the examination, if you clear some prelims or mains, you are appreciated, recognized. But if you have not cleared any examination, then you are unrecognized. Even after clearing the examination, say you have cleared only prelims cleared, mains, mains cleared, right? So that is there with respect to what? The aspirant also. And once you have cleared some level of examination, then you also get the right to give wrong advice to the advice to the upcoming aspirants. Anyway, so election commission decides the criteria for recognizing parties. Not just that, if there is any issues with respect to splits, mergers in the party, it's all the ECI which decides on such issues. Clear? Then it decides election symbols also and any disputes with respect to the same. So the election symbol that the parties have is allocated to the party by the ECI. You can't choose your own election symbol. They have a list of around 800 to 1000 election symbols. It is not some tattoo drawing you choose on your own. No, because that election symbol has to be replicated on the EVM also. So that is why basic household items for easy recognition and retention by the common person is chosen. And lastly, you have to fix the poll limit also, meaning there is a limit beyond which our candidates cannot spend. No limit on the expenditure by a party. Party as a whole can spend any amount, but as an individual, you cannot spend more than a certain amount. So, in the case of Lok Sabha elections, what's the amount? And in the case of assembly elections, what's the amount? So it is 95 lakh rupees per person per constituency in case of a large constituency. Election Commission decides which constituency is large, which is small. And it is 75 lakh rupees for a small constituency. In the assembly elections, it is 40 lakhs for large and 28 lakhs for small constituencies. Are we clear? This is mentioned in the rule number 90 of the conduct of election rules 1961. Okay, so this is the limit. Let me clarify, this is the biggest joke in the country. This 95 lakh was recently increased. Till 2019, this upper limit here was 70 lakhs only. And in the state, this upper limit was 28 lakhs only. This one was 28 lakhs. Please tell me, is it really true? The Association for Democratic Reforms, it has conducted some on-field surveys to find that in across 80 different constituencies out of 543 constituencies, 80 constituencies were such that the money spent by every candidate on average was over 40 crore rupees. 40 crore rupees. In the 2019 elections, the total expenditure made by the parties and ECI in conducting elections unofficially is roughly 55 to 60,000 crores. 55 to 60,000 crores. Of course, as a voter, you have also started demanding way more. Now voters don't accept small bribes. Now voters want 5,000 rupees, 10,000 rupees. Earlier, voters were happy with a packet of biryani, one quarter bottle. Now voters' demands have also increased. People are spending more money. 470 to 480 MPs were crorepati's, and these crorepati MPs, their average assets was 20 crores on an average. 20 crore rupees. I mean, for I won't say most, for over 90 to 95% people in our country over their entire lifetime, they will never see this much amount of money in their entire lifetime. 95% Indians will never see this money. Most of you here, if you choose to be a civil servant and an honest one, you will never see this money. That's the average assets of people who became members of parliament in 2019. Elections are free. Yes, they are free. You are free to choose. Inside the polling booth, it's secret ballot. Are they fair? I leave it for your better judgment whether they are fair or not. One more thing. Atal Bihari Vajpayee, largely respected by one and all, he in the parliament had made a statement that every politician in the country begins his legislative journey with a lie. And what's the lie? The lie is that he has been able to limit his election expenditure within the what? Within the certified limit. That is the lie that one former prime minister said in the parliament. So we know very well how true all this sham is. It's just a sham, sadly. Anyway, so that is again one more reason. So I know you have plenty of reasons to clear the examination. One reason from my side to clear the examination is to ensure that in future you make sure that wherever you are posted in your constituency, that person wins the election who does not have the maximum money but is the right candidate, right? And it's your duty not just to ensure that elections are fair, but also to ensure that voters are aware. How you'll do it is up to you. Okay. This expenditure is done by the candidate during campaigning. Now solve this question. Came in the year 2017. Easy and simple question. Okay, the Election Commission of India is a five-member body. How can six people have marked A as correct? It's a crime. It's a crime. Don't mark any random answer, guys, please. The Ministry of Home Affairs decides the election schedule. Why will the Ministry of Home Affairs, imagine Amit Shah deciding the election schedule, right? This is wrong. This is wrong. This is wrong. We have the answer. Election Commission resolves the disputes relating to splits mergers of the recognized political parties. Absolutely correct. Okay. In case you want to read the chapter Lakshmikant, chapter 42, let me write this here. Excuse me. Important articles 325, 326, and of course 324. Done. Now let's move on and understand the two laws that we have which deal with the conduct of elections in the country. One such law is RPA 1950 and the other law is RPA 1951. Now, why do we have two laws? This question was asked to a former Chief Election Commissioner SY Qureshi also, and he has responded to this question, and I will respond in the same manner as he has responded. So when people asked him on why there are two laws to deal with matters of elections, RPA 50 and 51, he responded, the former Chief Election Commissioner, I don't know. So if the former Chief Election Commissioner does not know why there are two laws, don't expect a polity faculty to know why there are two laws. Anyway, we could have very easily merged those two laws. But if you want me to create a difference, then I can simply say that the RP 1950 deals with the voter and 51 deals with the candidates and the general conduct of elections. So 50 is a smaller law, and I would request you to mug up this point, this entire paragraph. It would be easy to write a question in the prelims, in the main examination, the interview. If a question is asked on RP 50, that can be your interview, that can be your, sorry, introduction statement. That allocation of seats, delimitation of constituencies, qualification of voter, preparing voter list, manner of filling seats in council of states. All these things are a part of RPA 1950. Okay, that's it. Now, let's look at RPA 1950. These are the various sections here, not important, ignore it. Focus on this. Now, you already, I think, should be aware of this because we have already seen this. How many MPs are there from your state? Allocation of seats to the states in House of People in the Lok Sabha. Where is that mentioned? This is mentioned under Schedule 1 of RPA 1950. What is a SCIC reservation in the House of People? Where is this mentioned? Schedule 1 of RPA 1950. Total number of seats. How many seats for your state, MLAs in your state? This is mentioned under Schedule 2 of RPA 1950. Allocation of seats in the councils. Where is that mentioned? Schedule 3 of RPA 1950. So all these things, this, this, and this, it's all mentioned under RPA, Representation of People's Act 1950. One more point. Allocation of seats to Rajya Sabha, to states in Rajya Sabha. Where is that mentioned? Tell me. Schedule 4 of RPA 1950. Yes or no? Some of you are writing yes. So sweet. Schedule 4 of the Indian Constitution. Not RPA, everything RPA. We have studied that beforehand only. Allocation of seats to states in the Council of States. That is mentioned in the Constitution. Then the officers. So what categories of officers do we have? So number one, we have the Chief Electoral Officer, the CEO, the head in every state. Then for districts, we have the DEOs. All are IS officers. Returning officer. This is a person who is appointed for every constituency. Returning officer. What is he returning? He is returning to the people of the area a winning candidate. That's why he's called a returning officer. He is the person in charge of conducting elections for the entire constituency. In the Lok Sabha or for the Lok Sabha election, this person is a district magistrate. For the assembly elections, this person is a sub-divisional magistrate. Okay. Now, we also have polling booths. Entire constituency is divided into various small areas. For ease of voting, we have separate polling booths. In every 2 or 3 colonies, one polling booth. So the criteria is that for every polling booth, maximum 1500 voters are allocated. And election commission says that ideally every voter should have a polling booth within the range of 2 to 3 kilometers so that you don't have to travel too much to vote. That may not happen always, but usually it's the case. Now, in the polling booth, we have officers who are known as presiding officer, who is the head of the polling booth, plus other polling officers who are given various types of duties. These are people who are a part of the polling booth. So all those people who have ever gone to vote, the person who controls the EVM, that person is usually the presiding officer. And then there are other people. Somebody will put an ink on your finger, somebody will verify your voter ID card, all these things. Polling officers, right? These people are bank employees, government staff, school teachers, such kind of people, right? So basically, these are the employees who are given to the election commission for a few days on deputation, and they help the ECI in conducting elections at every polling booth. Now, election commission also has a task to update the voter list, right? Now, ECI don't think that the chief election commission will go to every house and say, how many of you turned 18 in your house this year? Oh, you, name added. Oh, that person died, name removed. CEC cannot do all these things. So what they do is that they have hired a person, a very unique concept. Since 2006, election commission has come up with an idea. They have also modified the RPA to add this post, section 13B, subsection 2, that some local government, semi-government or local body employee government, semi-government, local body member or employee. This person's task is to update the voter list. Okay. Because every time before the election, we have to ensure that all those people who have turned 18, all those people who have turned 18, their names are added. All those people who have passed away, names have to be removed. If you have changed your constituency, name has to be removed. If you have come to this constituency, name has to be added. If you have given up the Indian citizenship, name has to be removed. So voter list has to be updated regularly. BLO performs this task. And BLO will also help the people with respect to information, registration forms, all such things. So think of this person as the representative of ECI at the grassroots level, the election commission's representative, and we call this person the friend, philosopher, and guide of local people when it comes to the conduct of elections. And booth level officer is for every polling booth. Okay, so this is with respect to the BLO, booth level officer. Are you clear, everybody? Any doubt? No doubt. Karan, micro observer. Karan, polling officers can be given various names. Polling officers can be called micro observer. They can be called cameraman. Don't think that the election commission hires some professional cameraman, right? Dabbu Ratnani comes with his camera. No, no. Some government employee only. He is told that you are managing a very nice polling booth. If you find that the entire area is very nice and orderly, click a photograph. We can use the photograph in the triple IDEM, the institute that we run, and we'll show the people that look at this, how amazingly we conduct the elections. That's the point. Clear? That's it. No doubts now? Jayant, this time I have selected as polling agent. Congratulations. Great. Amazing. Let's now take a break. After the break, we'll come back and we'll continue our discussion on the types of voters. How many types of voters do we have? We'll discuss after the break. Okay? Break, please, guys. Come back at 5:35. No problem. Okay? Break, please. Are there any incentives for polling officers? Yes, Parshuram, presiding officer, polling officer are paid money. That depends on the returning officer. You will decide how much money. Normally, not a huge amount. In the range of 500-600 rupees to 2,500 rupees, depending on which area you're working in. If it's a difficult area, then the presiding officer can get 2,500 rupees also. If it's a smaller area or it's like a city, not much problem in a city to run to run a polling booth. So there maybe 1,200, 1,000. That's it. Don't expect too much money. Clear? Jane, that 2,400, 1,350, 1,100. Okay, this is in your area. It varies. This number depends on the returning officer. He or she decides what is the value to be given. Totally dependent on you. Are you clear, guys? All questions done. Should we take a break now? Be back at 5:35. Okay, break, please.